Special counsel Jack Smith filed a brief to set a trial date in the new criminal case filed against Donald Trump in Washington, D.C. federal court for 2020 election crimes, to set that trial date for January 2nd, 2024. Jack Smith states in his brief that this trial date on January 2nd, 2024 is in the interest of justice, and that the court, federal judge Tanya S. Chutkan, should not allow Trump to engage in his usual delay tactics. The difference between the law and order judge in Washington, D.C. federal court, Judge Tanya Chutkan, and the sloppy and corrupt Trump-appointed judge in the federal court for the Southern District of Florida, Judge Aileen Cannon, was again on full display this week. On the one hand, in Washington, D.C., you had Judge Chutkan moving that criminal case along expeditiously, entering a protective order, and of course, admonishing Donald Trump's lawyers for their behavior and Trump's behavior. More on that in a bit. On the other hand, you had Judge Aileen Cannon striking documents submitted under seal by the government for grand jury secrecy, while parroting arguments that Cannon might have heard on Fox the night before from surrogates of Donald Trump, and randomly putting those arguments in her orders on her own initiative. Seriously? Meanwhile, Donald Trump is asking Judge Aileen Cannon for taxpayers to build a sensitive compartmented information facility, or SCIF, at Mar-a-Lago so he can review the classified documents he stole in the case, in the crime scene that is the subject of the case. Once again, seriously? Next, let's turn to Fulton County, Georgia, where we expect not only an indictment against Donald Trump next week for his crimes relating to the 2020 election in Georgia, but indictments against at least a dozen other co-conspirators. I want to get Popok's take on who those other co-conspirators are who will be indicted. Donald Trump, meanwhile, has been threatening and harassing Fulton County District Attorney Fani Willis in some of the most disgusting, misogynistic, and racist ways. And Fulton County District Attorney Fani Willis had to respond, sending a letter to her staff telling them, please ignore it, stay professional in the face of all of these threats. Finally, MAGA hypocrisy exposed. Again, seems like that's a headline every single week. We had Merrick Garland appointing a United States Attorney, David Weiss, who was originally appointed by Trump, who is a Republican, and Weiss has now requested and was immediately given the status as a special counsel in the Hunter Biden criminal case and criminal investigation. MAGA Republicans were saying before that this was a cover-up, that he was not given this status in their obsession with Hunter Biden's nudes. But now that David Weiss became a special counsel after requesting it for the first time with no strings attached whatsoever and never being rejected in the request before, now MAGA Republicans go, you know what? That Trump-appointed prosecutor, that Republican Trump-appointed prosecutor, deep state. He's a deep state Biden, Dark Brandon operative. Insanity. Let's talk about law and order. Let's talk about evidence. Let's talk legal AF. I'm Ben Meiselas, joined by the one and only Michael Popok, the Popokian. What's up, Popok? How are you?
I'm doing great. Fresh off my stint in Fulton County, Georgia, reporting live from the courthouse. We'll talk about that a little bit later. But this compare and contrast that you and I have been talking about offline between Judge Cannon, and Judge Chutkan, which is exactly what Jack Smith wanted in this, what I call the portfolio approach of him filing in multiple jurisdictions. He knew he made a strategic decision that he had to file, and we'll talk about it when we get to that. He had to file the Mar-a-Lago case, he believed, in the Southern District of Florida, and he knew there was a 1 in 4 chance that he would get Aileen Cannon, given the way the wheel spins in that district. But he also knew that the bigger, badder case, the broader case, the more sweeping case, the Jan 6 case, was going to be filed on home turf for the Department of Justice and him in Washington, D.C. And his odds of getting somebody professional, sober, powerhouse like Tanya Chutkan to stand in sharp contrast that he could use as a model without saying so for to try to keep Cannon on the straight and narrow. We'll talk about how that's working. This was part of the mastery of Jack Smith that we're seeing played out, and we talk about here through a number of our segments.
I think fortunately, Judge Aileen Cannon's corruption is matched by her inexperience, and I might be a little crass in saying it, but I think the legal AFers will agree, her stupidity, and she is creating yet another legal quagmire in her courtroom, striking documents that special counsel Jack Smith is submitting under seal because of grand jury secrecy in fairly routine hearings, then inviting briefing on areas, again, outside the scope of her jurisdiction. We'll talk about this in a little bit in the show, asking for briefing about what's going on in grand juries in Washington, D.C. I mean, the whole reason why she was previously overruled in scathing orders by the 11th Circuit Court of Appeals is precisely because she was doing things outside of her jurisdiction for the benefit of Donald Trump, who appointed her, which is why she should have recused herself from the outset. But the legal quagmires, I think, that she's creating there ultimately are going to lead to appeals and delay in her case. But what comes right with that, what swoops in, you have the D.C. case right here, and special counsel Jack Smith, I think, seeing that opportunity, the fact that you have Judge Cannon setting, her trial date in May of 2024, but that's probably going to get pushed back based on all of the appeals and things that will start happening there as she creates such a sloppy and disorganized docket. But to me, this creates great opportunity, Popok, and Jack Smith is strategically seizing that opportunity by saying, look, we've got the case about Donald Trump's crimes relating to the 2020 election in Washington, D.C. Sure, maybe the willful retention of national defense information, Trump's theft of classified documents, and obstruction of justice case, maybe that gets kicked a little longer, but this case in D.C. can put Trump in jail for the rest of his life. We want that trial date. That's precisely what Jack Smith asked for. Talk to us about that.
It's beginning to look a lot like the Mar-a-Lago case is the stalking horse, and that the real case that Jack Smith is going to use to get Donald Trump behind bars, even though the easier case, factually, may be the Mar-a-Lago case. It is obvious that when he filed the Mar-a-Lago case, at the right moment, when the Mar-a-Lago indictment was ready to be obtained from the grand jury, we'll talk about grand juries in this Legal AF, but that he always knew, we all knew, there were multiple grand juries being used, including in D.C., and that the bigger one, the larger one, the more opus one, was going to be the one involving everything Jan 6, the interference with the election and the peaceful transfer and all of that. So you want to talk about, we're going I think throughout, the one theme here on the podcast is going to be the compare and contrast, not just of the two judges, but how Jack Smith so artfully filed one against the other, is using one against the other. Look, when they file in Chutkan's chambers, they know it's messaging that's going to be used or could be used in Mar-a-Lago and vice versa. Things that John Lauro, and Blanche, who doesn't talk much at this point, he's not admitted yet. Maybe he just got admitted in D.C., but he wasn't at the time. The things that they say, which are inconsistent, which we're going to talk about, things they've said about former President Trump should be given special treatment in Mar-a-Lago, and yet we have Judge Chutkan saying no special treatment. It's just his day job running for office. He's a regular criminal defendant, and you're out on bond, and we'll talk about that at my hearing.
Let's go into the motion or the briefing on the trial date. Jack Smith requesting this January 2nd, 2024 trial date here, and a whole workback calendar as well. Jack Smith wants a January 2nd, 2024 trial date, jury selection December 11th, 2023. final pretrial conference December 8th of 2023, and then all of the Rule 12 and other dispositive motions like potential motions to dismiss and things like that could be filed by September 25th of 2023. In this briefing, filed by Special Counsel Jack Smith, he reminds the court that the Speedy Trial Act is not just for the benefit of criminal defendants, it's also for the benefit of the public, the American people, and that this trial date is in the interest of justice. The briefing goes on to explain how the government is prepared and ready to make all of the discovery available to Donald Trump's lawyers. You know, one of the notable things in this order was you had a situation where Trump was, the new MAGA conspiracy was that the January 6th committee destroyed all of its records. So now that Donald Trump has subpoena power because of this case, that's going to be exposed. It's an insane conspiracy on multiple levels. Donald Trump had subpoena power before as well in some of the other criminal cases, but also, you know, who had subpoena power as well? Congress, the MAGA Republicans who use their subpoena power to talk about Hunter Biden's nudes instead of actual real issues that matter to the American people. It's also doubly insane because the January 6th committee documents are easily accessible online. When the MAGA Republicans took over the House of Representatives, they were the ones who disbanded the committee, took down the public website. So the January 6th committee had to archive it and make it available online. But also, we're going to talk about the protective hearing that went down in a little bit. Special Counsel Jack Smith was trying to turn over all this information to Trump, even on an interim basis, before the judge entered into a protective order. So Jack Smith's like, here, we'll turn over everything for you. Grand jury transcripts, exhibits, witness interviews, recordings, the vast majority of all materials obtained through search warrants, unredacted materials obtained for other governmental entities, including the House Select Committee to investigate the January 6th attack on the United States Capitol and the United States Secret Service. And Donald Trump's lawyers were like, we don't even want to enter into an interim protective order while we wait for the judge. We want to delay. So Jack Smith is calling him out there. But Jack Smith's like, look, discovery's ready. The interest of justice under the Speedy Trial Act for the American people supports this January 2nd, 2024 trial date. And then Jack Smith cites a number of other cases that have been tried in a similar time period. Ultimately, I believe that Judge Chutkan will probably set, I think, a February or March trial date. I don't think she sets the January date, but I think she'll set a 2024 trial date. But now that the protective order has been entered, we'll talk about what went down at the hearing on a protective order. This case is going to be moving quickly. Judge Chutkan throughout the week was making ruling after ruling, no delays, holding everybody accountable to very quick deadlines, and she would issue minute orders. I mean, while we were live last week on Legal AF, there was a flurry of minute orders taking place at that same time. And of course, Donald Trump's responded to Jack Smith requesting this January 2nd date by saying, deranged Jack Smith has just asked for a trial on the Biden indictment to take place on January 2nd. Only an out-of-touch lunatic would request that. Election interference. But Donald Trump's posts were brought up at the protective order hearing, which we'll talk about shortly, before Judge Chutkan. And she did something brilliant there to basically tell Trump, hey, you're going to continue engaging in that type of conduct. It makes me more likely to set an early trial date, just so you know, so that there's no taint in the jury pool. But all of these motions are being moved along quickly. Popok, what do you think about the trial date? And then next, maybe talk through all of the back and forth on this protective order, what went down in this very powerful hearing.
Yeah, I think I'll start with the hearing and I can backfill for the trial because they're going to be linked together. Because the hearing that led to the protective order, which has now been entered by the judge, and Ben, when I turn it back, you can go over the details of it. But what was fascinating to watch was the amazing shrinking former president in the hands of a federal judge, Judge Chutkan, who knows how to run a courtroom. He became about 3 feet tall in that courtroom as Judge Chutkan sat 10 feet above him in a black robe with the American flag behind her. And she let it be known that if his only experience in federal court criminally to date had been Aileen Cannon, who bent over backwards when she interfered improperly, unconstitutionally with the Mar-a-Lago criminal investigation in progress and was chastised twice by the 11th Circuit, her bosses, as a result of that. When she made comments then last summer about extraordinary defendant in front of her, former presidents get different treatment in federal criminal cases. If he thought that is how he learned about federal criminal law, welcome to Judge Chutkan, because Judge Chutkan did a number of things and said a number of things in the hearing in which, without reading between the lines, it was the lines. She told him point blank, and his lawyers, I am not going to treat your client any differently than any other criminal defendant in front of me. That's one. Two, politics is going to be left at the doorstep. Politics are not going to play a role in anything that I'm going to decide in terms of the protective order and, of course, by implication, the trial setting and other things leading into the trial. The third thing she said to him is the thing that he does in campaigning, that's his day job. Just like any other criminal defendant has a day job. This, again, is the laser ray of Chutkan, Judge Chutkan, shrinking Donald Trump. Like Honey, I Shrunk the Kids. This was Judge shrunk the former president down to size so that she can control him and let him know, and that she's also been reading, including things filed by Jack Smith's team. The other thing that shrinks him down to size and shows that she's going to be treating him like anyone else, and we'll put it up in a minute, is in her minute order, which I loved. She referenced the defendant is still presently out on bond in personal recognizance. She took time to remind him that he and his release into back to liberty is subject to her supervision. Okay, period. Nothing says you're just a regular old criminal defendant in my courtroom like a reference to your bond and your release conditions in the minute order when she was done with her hearing. Okay, during the hearing, of course, she took head on the argument, the defense that's being run in all of the news shows by John Lauro and by Donald Trump in his social media about, I have a First Amendment right. I have a First Amendment right. It's my defense. It's a First Amendment case. It's my First Amendment right. She said, okay, let's get something straight. This is in the courtroom, as reported by people that were present. You have a First Amendment right, just like any other person in America does. However, you're also a criminal defendant. And as a criminal defendant, there are limits to your, and she's talking to John Lauro at this point, your client's First Amendment rights. And the limits are, it can't interfere with the proper administration of justice. And I'm going to make sure that that apple cart of justice is not overturned by your client's First Amendment rights. And I'm watching him carefully, obviously triggered appropriately by what Jack Smith put in his filings, in which he said, well, now he's threatening people. Now he's just bald-faced threatening people. Now he's just saying, you're coming for me, I'm coming for you. She said, she didn't say I'm troubled by it, but you could tell in her reaction to it. You could tell she was reacting to that and said, I am concerned about witness tampering and possible jury tampering by statements made by your client. So he is forewarned in this courtroom, and then of course it's baked in to the written protective order, that if he crosses those lines, my primary job is to make sure that judicial efficiency and justice is done. And I am going to use whatever in my power is necessary to sanction your client and restrict him in order for those things to be protected. She's very concerned about witnesses who can't protect themselves, who are going to be bashed like Mike Pence and others by Donald Trump going forward. And she's very concerned about the potential jury pool being selected and him trying to influence and shape the results about that. So much so, as you said at the top of the segment, Ben, Judge Chutkan said, And this is where she ties her comments and her thought process, because this was our first opportunity to see inside the mind of Judge Tanya Chutkan and how her mind works as it relates to this criminal defendant in front of her, who happens to be a former president, which is basically how she approached it. She said, and if you keep it up, one of the things I may do is speed up the trial date, meaning I know you're pushing Mr. Lauro for beyond, she didn't say this, for beyond January. The more your client violates my warnings, my cautionaries, the more likely it is that we're going to go to trial faster, not later. And so it was great because it was like a shot across the bow before they file their paper, which they have to file based on a briefing schedule, the judge asserted. We know from Mar-a-Lago, just as there, the Jack Smith's team said December, the other side said, I don't know, after November, Your Honor, and the judge sort of picked the middle. Same thing here. This case, they said, which has less confidential information issues, although there are still classified information issues. We will play the marker down as January with a pre-Christmas, I love this one, pre-holiday, pre-Christmas jury selection process. And then waiting on, obviously, they're going to do the same thing. 2.5 years to investigate. We want 1.5 years. We want to go beyond November. I don't think there's, based on the comments made by Judge Chutkan aloud in the courtroom about the protective order, I don't think there's any way in heck she is going to push this out. I don't think she's going to pick January. But like you said, I think she's looking at this calendar. Alvin Bragg has already said aloud in an interview in New York that he's willing to move his trial date in March to yield to a federal trial date that would be that would be asserted. So he's willing to take a step back and give Judge Chutkan a new date opening, which then supports your February, March. I think it's February, March, April-y kind of thing. And if Cannon screws around with her trial date anymore, and we'll talk about her later, while that is likely to happen, then as you said last week, Ben, then Chutkan just slides right in there. So if Alvin Bragg, Manhattan DA Stormy Daniels case moves off the docket and yields to the federal case for now, staying his case until another date, and then Cannon screws around, there's a huge swath of time after January, but way before November during Republican primary season. But this judge doesn't care about that to set this trial.
So on Friday during this protective order hearing, John Lauro started off by saying, well, Your Honor, Judge Chutkan, we all know that there's a political campaign, and she stopped him right there. She admonished him right there and said, I don't care that there's a political campaign. The government filed when the government was ready for their case. I could care less that he's running for office. It means nothing in my courtroom. And her words were so powerful, I'd like to read them directly, what she said based on what court observers transcribed. Judge Chutkan said the following to John Lauro. Lauro, you are conflating what your client believes he needs to do you're conflating what your client needs to do to defend himself and what your client believes he wants to do politically. Your client's defense is supposed to happen in this courtroom, not on the internet. She continued, what the defendant, Mr. Trump, is currently doing, the fact that he's running a political campaign, has to yield to the orderly administration of justice. If that means he can't say exactly what he wants to say about witnesses in this case, that's how it has to be. That's how it is going to be, Mr. Lauro. Mr. Trump, like every American, has a First Amendment right to free speech, but that right is not absolute. Defendant's free speech is subject to the release conditions imposed on him at his arraignment, and it must yield to the orderly administration of justice. I, Mr. Loro, intend to ensure the orderly administration of justice in this case as I would with any other case before me. Even arguably ambiguous statements from parties or even their counsel that can threaten the process, I will deal with accordingly. In addition, the more a party makes inflammatory statements about this case, which could taint the jury pool, the greater urgency will be that we proceed to trial quickly. I will take whatever measures are necessary to safeguard the integrity of these proceedings. Do you understand, Mr. Loro? Incredibly powerful stuff right there. Want to talk more about these proceedings and what also went down around the same time in the Southern District of Florida as Judge Aileen Cannon lost complete control of her courtroom after this quick break.
Oh, hey, I didn't see you there. Look, everyone knows how annoying cheap razors are. The cuts, the irritation, the frustration. And don't get me started with subscription razor services, the headaches that those can cause. That's why you gotta meet Henson Shaving. Henson Shaving is a family-owned aerospace parts manufacturer that has made parts for the ISS. That's the International Space Station and Mars rover. And now they're bringing precision engineering to your shaving experience. Razor blades, they're like diving boards. The longer the board, the more wobble. The more wobble, the more nicks, cuts, and scrapes. A bad shave, it isn't a blade problem. It's an extension problem. By using aerospace-grade CNC machines, Henson makes metal razors that extend just 0.0013 inches, which is less than the thickness of human hair. That means a secure and stable blade with a vibration-free shave. It gets better. The razor has built-in channels to evacuate hair and cream, which makes clogging virtually impossible. Seriously, Henson Shaving wants the best razor, not the best razor business. That means no plastic, no subscriptions, no proprietary blades, and no planned obsolescence. The Henson razor works with standard dual-edge blades to give you that old-school shave with the benefits of new-school tech. Once you own a Henson razor, it's only about $3 to $5 per year to replace the blades. My first shave with the Henson razor was incredibly refreshing. The design is sleek and the durability is top-notch. The Henson razor is truly so much better than your run-of-the-mill quote-unquote traditional razor brand. And the affordability factor is absolutely game-changing. No more wasting your money on expensive blades. With Henson Shaving, you can get a year of blades for just $5. Okay, so this is what you have to do. It's time to say no to subscriptions and yes to a razor that'll last you a lifetime. Visit hensonshaving.com/legalaf to pick up the razor for you and use our code LEGALAF and you'll get 2 years worth of blades free with your razor. Just make sure to add them to your cart. That's 100 free blades when you head to hensonshaving.com/legalaf and use code LEGALAF.
This is Michael Popok from Legal AF. If you're like me, you understand the pains of choosing what to wear. Let's face it. Most clothes are uncomfortable, or too tight, or are never actually the size you really are. Not to mention the annoyance of trying to put a good outfit together. And when you do have a good fit, you can only wear it for a few hours before you have an important meeting or dinner, and then you got to change all over again. Everyone wants to dress the best and look good at all times because, frankly, it's a confidence booster. So here's the deal. Men's closets were due for a radical reinvention, and Rhone stepped up to the challenge. Rhone's commuter collection is the most comfortable, breathable, and flexible set of products known to man. And here's why. Rhone helps you get ready for any occasion with the commuter collection, which offers the world's most comfortable pants, dress shirts, 1/4 zips, and polos. You never have to worry about what to wear when you have the Rhone commuter collection. Rhone's comfortable 4-way stretch fabric provides breathability and flexibility that leaves you free to enjoy whatever life throws your way, from your commute to work to your 18 holes of golf. It's time to feel confident without the hassle. With Rhone's wrinkle release technology, wrinkles disappear as you stretch and wear the products. It's that easy. And with its Gold Fusion anti-odor technology, you'll be smelling fresh and clean all day long. And on top of that, Rhone is 100% machine washable, so you can ditch the dry cleaner altogether. I absolutely love Rhone. As you can see, this has truly become my go-to commuter fit and on the Legal AF podcast recordings. We're on the move a lot, whether it's jumping from meeting to meeting or catching a flight or an important dinner. The Rhone commuter collection has never let me down. The versatility and comfort of the collection is undefeated. Even after I wear it all day, I still feel super fresh because of that Gold Fusion anti-odor technology. The commuter collection can get you through any workday and straight into whatever comes next. Head to rhone.com/legalaf and use promo code LegalAF to save 20% on your entire order. That's 20% on your entire order when you head to RHONE/legalAF, promo code LegalAF. Find your corner office.
Welcome back to Legal AF. We are live. I'm Ben Meiselas, joined by the one and only Michael Popok. Where we last left off, I went over exactly word for word what Judge Chutkan said to Donald Trump's lawyers at the hearing on Friday. And then shortly after the hearing, very expeditiously, she entered the protective order. The protective order is keeping basically all of the documents that the government wanted confidential and remaining under seal. Certain categories of documents will be presumptively labeled sensitive materials. I saw some reporting that said, well, she did give Donald Trump's lawyers what they were asking for. I get that. I don't fully buy that take, though, because all she was basically saying to the government is that not every single document could be viewed as presumptively sensitive material. Like there has to be certain categories and limitations, which the government was always fine with from the outset. The government basically got everything they wanted. So I don't really get that take. That was
this both sidesism. I saw NPR's report. I saw a couple of other commentators' reports about mixed bag ruling by the judge. You have to make a major stretch to find that Donald Trump got any bone at all from Judge Chutkan. She threw him one bone, and it was completely, I'm sure, expected, as you just anticipated, Ben, by the government, that they would only be able to protect sensitive information from his constant use of it in social media posts and at rallies, but everything else would be sort of fair game and subject to the public domain. And because, as you said earlier, it's not just, that's what John Lauro always misses. It's not just the defendant, even the government, that has speedy trial rights, or the defendant. It's the public has a stake, has a place at the table. Public trials is the hallmark of our criminal justice system. We don't do secret trials like in other countries that we're not supposed to be trying to emulate. We do public trials, and the Right to Speedy Trial Act embodies that. So we have the right. This is why things generally in civil or criminal cases get unsealed and unredacted and given over to the public so they can help make their own decisions. We're going to talk at the end of the podcast about Hunter Biden and the new special counsel and the report that will ultimately be generated from that, and how much of that report, or any of that report, that would be disclosed to the public. We'll talk about that. But that is the reason why. And that's the reason why, after search warrants are done being executed, magistrate judges revisit, okay, you had all these redactions and black lines, government. I'm going to start stripping them away because the public has a right to know about these things. The most remarkable thing, every other thing that happened in that hearing was against Donald Trump. Donald Trump's position, anticipated his future arguments, shut them down, and got him drilled down to size. One thing that was very good in the transcript sort of reporting that you did, one comment that she made that I saw reported in another from another reporter that was in the room, is that she said Judge Chutkan said to John Lauro that even ambiguous statements by the parties and their counsel, and she's looking at Trump when she's saying that, could be considered by the court to intimidate witnesses or projected or possible jurors, and you need to tread lightly there. So she said, and I caution you and your client to take special care in your public statements. I will take whatever means are necessary to protect the integrity of my judicial process. Look, leaving that courtroom now, the judge has now set up, and she's entered the order right after that, tripwires that Donald Trump will likely trigger and blow himself up. A, he can't help himself. B, his lawyers have absolutely no control over him or what he does on the rally or the campaign, that world. They even say, we're not in charge of that world. We're just the lawyers, Your Honor. We're not handling his campaign. Okay. She has now gave tripwires. And every time he says something out loud, right, Donald Trump, Jack Smith's team, and we know there's people assigned to do this, will take that transcript, will take that social media posting, and they will do another filing. And if people think this is a joke, right, what a federal judge says to a criminal defendant about the conditions of release and warnings like this one, they're not empty threats. We'll talk a little bit later, and I'll do a hot take on it. We have a federal judge who gave a similar set of warnings about witness tampering and other things to Sam Bankman-Fried, the disgraced former founder of FTX. And when he violated those many months later, because he was testing, putting his hand on the stove, seeing what he could get away with, the judge in New York is now putting him in jail, pretrial detention before trial because of things that he said or did. It is no joke when a federal judge gives you instructions and warnings and cautions. And this is John Laurow's problem. A, he doesn't listen. And B, his client certainly doesn't listen. As an old client of mine once said, I can tell it to you, but I cannot hear it for you. And now I don't think anybody's going to be shocked, and I think we're all rubbing our hands in glee waiting for it, when Donald Trump violates Judge Chutkan's instructions and the federal government puts her on notice and she calls another hearing and sets sanctions for it. Does it lead to him ultimately being taken off the campaign trail and put in a federal detention center? I don't know. But there'll be severe sanctions if he violates her instructions.
And I think it's going to justify her setting this trial date on January 2nd, 2024, which is what Donald Trump fears the most. And I think what the government's going to do before the next hearing, which, by the way, is scheduled for August 28th, where that will be a trial setting conference, they're going to say, Judge, you said at the August 11th Friday hearing that Donald Trump's threats were one of the reasons also why there needs to be a speedy trial date to avoid the taint of the jury pool intentionally trying to be caused by Trump. Here's a list of all of the statements he's made before. Here is a list of the statements that he has made after. And it's going to put Donald Trump's lawyers there, John Lauro and Blanche, in a bit of a bind. And I think that's going to be a very, very powerful hearing. And I think she's going to set an early trial date. Going through the protective order.
And before you move on, sorry, just one last thing about speedy trial, just because there's a lot of misinformation that's being promulgated by John Lauro on television. And I want to give you, and you do too, our audience some insulator about that and hold on some poll star to follow. Speedy, one of the reasons that you just laid out and the judge is referencing is baked into the Speedy Trial Act, which is if there is a chance that the defendant, though presumed innocent, could go on a crime spree and continue to commit crimes or as a bad person, you get them to trial quicker because they'll get their day in court and justice will be done. It is a justification, as she is saying, and she's not, this isn't the Chutkan rule. This is baked into constitutional analysis around the Speedy Trial Act and its purposes. And she is basically telling Lauro, one of the reasons I might put a trial earlier is because your client is misbehaving. And therefore, I won't put him in pretrial detention, but he's going to get his trial faster, not sooner. We'll see what a jury does about it.
Going through the protective order in under 60 seconds right now that was just entered, because I want to speak a lot about Judge Aileen Cannon. Paragraph 1 of the protective order explains that it doesn't apply to information that is publicly available. Paragraph 2 says that sensitive materials which the United States may designate in accordance with paragraph 8 below are subject to the protective order. Paragraph 3 says it may not be disclosed to people other than authorized persons, which are defined as the counsel for Donald Trump in this case and the parties of this case. You go to paragraph 8, it talks about what material shall be considered sensitive. This is the information produced during the grand jury process, recordings, transcripts, interviews, materials obtained from other governmental entities, materials obtained through search warrants. So basically everything that special counsel Jack Smith wanted. The grand jury testimony itself, and it also limits how Donald Trump can access the material. He has to access it with his lawyers. He can take electronics in when he accesses it. He can take handwritten notes, but Trump can take handwritten notes about personal identifying information, can have electronic devices when he reviews the discovery material. But who are we kidding? Donald Trump doesn't read anything, so I doubt he will even be looking at it based on those limitations in the first place. And if he does, there would be severe sanctions, including contempt. And again, Donald Trump could be thrown in jail for that. I want to go compare, though, everything we just talked about to what was going on in Judge Aileen Cannon's courtroom, because the contrast could not be more stark. So while you have Judge Chutkan expeditiously moving it along, this was an order that was issued by Cannon. It was an order striking filings and ordering briefing. And what went down in this order, it was in response to special counsel Jack Smith requesting what's called a Garcia hearing in the criminal federal system. A Garcia hearing is where there are unwaivable conflicts of interest by a defense lawyer in the case. In this case, Stanley Woodward, who represents Trump's co-defendant Waltine Nauta, also represents or represented at least 3 other witnesses, and he's being paid by Donald Trump's political action group. And some of the other witnesses have testimony against Waltine Nauta. For example, Woodward used to represent Yusel Taveras, who provided the critical information on the newest co-defendant, Carlos de Oliveira. And so there's all these conflicts. So special counsel Jack Smith said, Judge, we need a Garcia hearing, and under grand jury secrecy, here are the transcripts that show this conflict of interest. Judge Aileen Cannon gave an order striking the sealed filing, saying that there was not good cause shown by Jack Smith, demonstrated by Jack Smith. And Jack Smith's like, what are you talking about? Like, it's grand jury secrecy. I'm trying to give you the information about why there are these dangerous conflicts of interest, potentially rising to the level of ethical violations that should not be going on. You're just striking grand jury secrecy filings. But it goes beyond just striking the filing. She then says in her order, and it came out of nowhere, she goes to Waltine Nauta's lawyer, the Stanley Woodward, who would be the subject of the Garcia hearing. Among other topics as raised in the motion, the response shall address the legal propriety of using an out-of-district grand jury proceeding to continue to investigate and or seek post-indictment hearings on matters pertinent to the incident indicted matter in this district. The special counsel shall respond to that discussion in a reply in support of the motion due honor before August 22nd, 2023. The remaining defendants may but are not required to submit their briefs by August 17th. And then she drops this footnote 1 that says, this request for supplemental briefing is not intended to substitute and or limit any future motion brought pursuant to Federal Rule of Criminal Procedure 12B, which among other things is for a motion to dismiss the indictment. So she's signaling to Trump's lawyers and Waltine Nauta's lawyers there, I don't think you could read it any other way, that they could try to seek to dismiss the indictment based on, I don't know, grand jury impropriety. And then she's inviting a discussion. But she's doing a few things here at the same time. She's striking Jack Smith from filing under seal grand jury material, which are sacrosanct, which are secret. That's why you saw in Judge Chutkan's protective order that I just showed you, that material is deemed sensitive material and is always filed under seal. You don't need to bring any sweeping motions. It's always under seal. And now Judge Cannon wants the parties to brief about what matters are going on in a Washington, D.C. grand jury that is still hearing evidence about Donald Trump's crimes. In a manner that's not going to be secret, because she keeps striking them. So she's going to create, and she's created this legal quagmire, not to mention there's nothing wrong with having another grand jury in Washington, D.C. It also shows you she's doing the same thing she did in 2022, where she tried to assert jurisdiction over things that don't belong to her. Yes, Judge Aileen Cannon, the case before you, unfortunately, is before you, and you have jurisdiction over that. Special counsel Jack Smith used a grand jury from the Southern District of Florida to indict in the Southern District of Florida. He could have a grand jury in another state or another district investigating crimes that have a nexus to that grand jury. That's not a controversial proposition, but she's doing the same thing the 11th Circuit, slapped her down in their other order, saying, stop taking jurisdiction over things that don't belong to you, Cannon. And she wants it all because she wants the control, in my view, to try to help Donald Trump here. And that's why she's, raising this issue. But then it's also like, Popok, where did this issue even come from? And then what we found out, thanks to the sleuthing of Andrew Weissman, former federal prosecutor distinguished, that the night before she issued this order, that order was issued on a Monday. The night before that, on Fox, one of Trump's surrogates and former lawyers, Jim Trusty, went on the Mark Levin show. That's how Mark Levin talks. He goes, tell me about it, Trusty. This is, the guy, they're all like supervillain characters. Like, you can't make these people up. What? Tell me how corrupt this is, Trusty. And Jim Trusty made that argument, which Trusty knows better. He's a former federal prosecutor. He knows it's total BS. But then she took that argument and put it in this order sua sponte, meaning on her own initiative. And then Trump's lawyers were like, well, I guess we could just ask her for anything. So why don't we ask her to order the construction of a skiff in Mar-a-Lago, like in the crime scene. So Popok, talk to us about Judge Aileen Cannon.
Yeah, and I'm hard hitting. We don't blow smoke or sunshine on this show, but I still practice in the Southern District of Florida, so I'll give you my view of what's going on. We seem to have the same problem with Judge Chutkan. Judge Cannon that we had with her in the summer, and despite having been admonished by the 11th Circuit about her exercising jurisdiction and sticking her judicial nose in places it doesn't belong and constitutionally doesn't belong, it looks like she's kind of doing it all over again. And the stark contrast that you mentioned is that you have one federal judge who's properly, with justice being blind, in her courtroom with Judge Chutkan telling the criminal defendant in front of her, who happens to be named Donald Trump, who happens to have a day job of running for office, who happens to have been a former president, that he's not going to get any slack cut. He's not going to be treated any differently. And you contrast that with Aileen Cannon, who literally has said in writing during the Mar-a-Lago search warrant interference, I'll call it, for interference. If anybody's interfering, it's the federal judge interfering with an ongoing criminal investigation at that time, pre-indictment. She said, well, no, there are special circumstances. She said the exact opposite. And this is the problem. This is what's in the transom of her mind and animates her decision-making, is that she believes that because this guy in front of her is a former president, that she needs to bend over backwards and accommodate him in ways she would never do to any other normal criminal defendant. And nobody else on the federal bench with experience believes that. And that gets her, because that is a warped understanding of both who she has in front of her, the constitutional rights that he may have, and her role in that process. She's always off on the wrong foot when she makes her decisions, because her judgment is impaired because she doesn't understand her role, that she's in charge, that he has speedy trial, Sixth Amendment rights, but that's the limits. Instead, she bends over backwards. And then, because they know they have an umpire, to continue my baseball analogies, because they know they have an umpire with a strike zone that's whacked, they just keep pounding her strike zone, hoping that they'll get the pitch called their way. So when you have a judge that you think is off kilter and is in favor of creating special rules and special accommodations, then you do things like saying, for instance, in the request, which is, I can't even say it out loud without almost laughing, but the fact that they're putting it in front of her, there's a good chance she could rule on it. The argument on this, let's start with the argument on the skiff, and then I'll go back to her argument about grand juries, which is a fundamental misunderstanding of the federal rules on grand juries, the Department of Justice manual about grand juries, and how they're used. And we'll talk about that in a minute. And you're right, by the way, Jim Trusty saying it on Fox News or whatever, Jim Trusty does know better, but he also knows, because he worked next to Jack Smith headed a similar division at the Department of Main Justice, but he knows he's got a weak off kilter judge who doesn't have good judgment, no pun intended, when she makes these kind of decisions, because she's totally besotted with Donald Trump in front of her. So on the skiff, they'll say, you know what? Why don't we ask to rebuild the special secret, double secret probation reviewing room for classified information and let him do it at Mar-a-Lago or maybe Bedminster in New Jersey, or he can take it on the road with him or whatever. Because because as John Lauro wrote with Todd Blanche, these are exceptional and unusual circumstances, meaning Donald Trump, former president, currently on the campaign trail, to which Judge Chutkan in her courtroom said, I don't care what his day job is. Politics is left at the courthouse door, and it's not going to influence me. But they have somebody who has said, I got a weird situation. I got a former president. I might have to bend over backwards. So they're trying it. This should be rejected. If she rules that they can reestablish the skiff that was present while he was president, but was taken away after he was president, no longer president, meaning when he was withholding all the documents, they weren't being held in a skiff. And if she allows them to do that, then that goes right to the 11th Circuit, and she's going to get slapped again. She's going to get bench slapped by them again on this particular issue. As to her suddenly coming up either independently or because somebody in her household watched Fox News with the idea that she should somehow challenge the fact that there were two or more grand juries looking over similar issues for Mar-a-Lago. So let me just say this out loud because this gets missed. I saw every report in mainstream media and no one put the analysis in there that you and I are about to do, which is one, you are allowed as a federal prosecutor to have multiple grand juries, develop evidence, and you can take evidence developed in one grand jury and you can bring it in to another grand jury. It is literally an exception to the rule that governs grand juries, which I will cite. It's Rule 6. If you go to Rule 6 of the Federal Rules of Criminal Procedure and you go to little e, subsection E, 3, little c in the hole, as we like to say in the business, that section has an expressed exception for prosecutors to take information from one grand jury and share it with another grand jury. As long as all of that, so in other words, it allows hearsay to come from one grand jury into another grand jury. It's an exception to the rule that you usually have to put live witnesses and evidence in front of the indicting grand jury. So the only reason that she knows about this is because it's not objectionable and it's nothing to hide. And Jack Smith's team, when they filed their papers looking for the Garcia hearing, mentioned in the chronology that there is a grand jury in the District of Columbia looking at primarily the obstruction of justice issues and obstruction of official proceeding issues. There's a grand jury in the Southern District of Florida looking at those issues. And a superseding indictment came out at the end of July, which we now know was based on the testimony of Mr. Tavares, the IT worker who came, which they were able to grab, I assume, in the Southern District of Florida. It is not objectionable. It is not a violation of Rule 6, and the Department of Justice manual, which guides prosecutors in their role based on the law as developed, says it's not appropriate. Why she's sticking her nose and creating an issue for her to do mischief? Well, we know. I just answered. It's a rhetorical question. That's what she's doing. And this will, as you said, Ben, delay because she's going to get it wrong, because she gets it wrong every time because she thinks she's got a special celebrity in front of her that gets new rules made for him that don't exist in the Constitution or the Federal Rules of Criminal Procedure. And then the Department of Justice has to take an immediate expedited appeal to the 11th Circuit. And then we burned a month. And then all of a sudden she says, aha, now I can't do the May trial. That's off because, we were jerking around with the appellate process. The skiff, she'll screw that up too. If she will know the next time we get together,
she will screw it up.
If she screws this up and says, sure, portable skiff, take it wherever you want. Put it in an RV, put it in Bedminster, put it in wherever, Trump Tower, wherever. Because, it's very inconvenient for him to go to Miami where the skiff is located and have to look at documents. Now, there is one, again, these cases speak to each other. Chutkan thought that sort of making a lawyer babysit Donald Trump looking at documents, and these weren't even classified documents, was unreasonable. And she's going to let him look at documents. His notes have to be reviewed by the lawyers to make sure there's nothing in there that if he ever took these notes. And that may bleed over. We're going to watch bleeding over, and you and I will follow it closely and bring it to everybody's attention in Legal AF and Hot Takes, between what's going on in the world of Tanya Chutkan, Judge, and what's going on in the Cannon world and the positions that are taken. Because the Department of Justice is very careful about what they write in every one of their filings, just as they were careful about, when Twitter appealed because they didn't want to turn over all of Donald Trump's information about his Twitter account and how it was operated and who operated it, and they got fined because they were 3 days late. Talk about screwing around with a federal judge and their orders. Screw around and find out, you get $350,000 fine against you. It buried in there was a position that the Department of Justice took about what the Jan 6th prosecution is all about and what it's not all about. They are careful lawyers. The other side are sloppy lawyers, which are also married to a supremely rogue and sloppy client. And that's a rest. And then you got a judge who's very, very inexperienced. Look, I'll leave it on this, Ben. I saw some former judges take to the airwaves and in writing to say they had a little bit of empathy for Judge Cannon because she is so new and everybody makes mistakes when they first get on the bench. That's why you surround yourself, and it looks like she isn't. You surround yourself with a really strong law clerk, a really strong courtroom deputy, a really strong bailiff, a really strong people to help you because let's be honest, you don't know what you're doing. And these are all first-time things for her. So judges, when they first get on the bench, even Tanya Chutkan, 9 years ago, 10 years ago, is not the Tanya Chutkan of today. But that doesn't mean she doesn't have to do her homework, consult with some other judges, and consult with her staff and the law before she makes such off-kilter decisions.
And again, fortunately, her corruption is matched by her inexperience and, let's just say, it's stupidity, because that's actually created opportunity, which is why when ultimately Judge Cannon was assigned the case, I know that was freaking everybody out, and rightfully so, I said, don't worry about it. And perhaps I could have given I thought I gave good context, but if I didn't, having the patience may or may not be the right word, but having been doing this for a very long time, litigating in federal courts and state courts and seeing how these things ultimately develop, where you have kind of really bad checkers players, and then you've got Jack Smith playing like a multi-dimensional 8 games of chess at the same time. It creates opportunity where it may not be obvious at first. And the opportunity here is actually that I think the January 6th insurrection case is now going to be tried first. That puts Trump in jail for the rest of his life. Put Trump in prison forever. And so that right there is an opportunity that Jack Smith recognized. And ultimately, as Judge Cannon creates this legal quagmire, Jack Smith will go to the 11th Circuit Court of Appeal at some point in the near future. I think she will be overturned. And there's kind of a 3-strike rule that seems to exist in the 11th Circuit precedent when it comes to judges, at least in the other case where a judge didn't self-recuse. It was a case where the judge had gotten it wrong twice during sentencing. And finally, the 11th Circuit's like, you're off this case. And, we'll see if that's a possibility here. And then ultimately, if you have the current calendar, right, of October 2nd, New York Attorney General, civil fraud case against Donald Trump for $250 million, or seeking at least that. Then you have the Jack Smith, Washington, D.C. federal case. And then you have the Manhattan District Attorney case. We'll see where the Fulton County case comes in. And then you have Cannon. Maybe Cannon gets removed, but the willful retention of national defense information. At that point, with all of those cases going first, and then I forgot to mention E. Jean Carroll's civil case, a class action in January 2024 as well. I'd be okay if the willful retention of national defense information case goes after it, if it's all stacked like that. But we'll talk about what's going on in Fulton County in just a moment. Everybody, make sure you go to MeidasTouch.com as well. We've got the best pro-democracy content there. That's the new home of all things MeidasTouch. MeidasTouch.com, our new homepage with all the breaking news. We put all of the filings that we talk about there. Check that out, and also check out store.MeidasTouch.com. Get that new legal AF gear. We're going to talk a lot about what's going on in Fulton County, what's going on with the appointment of the special counsel. But first, we're going to take our last quick break of the day.
My old mattress would overheat while my partner and I were laying in it together, making for a terrible night's sleep. I'm so excited to say that this episode is brought to you by 8 Sleep. Summer is reaching its apex, and there's nothing worse than tossing, turning, or sweating in the night because of summer heat. The pod cover by 8 Sleep will keep you cool all night, all the way down to 55 degrees Fahrenheit, so you wake up fully refreshed. The pod cover by 8 Sleep fits on any bed like a fitted sheet. The pod cover will improve your sleep by automatically adjusting the temperature on each side of the bed based on your and your partner's individual needs. It can cool down and warm up and adjust based on the phases of your sleep and the environment that you're in. I love 8 Sleep because we spend almost half our lives in bed, so improving our sleep routine, habits, and overall sleep quality should be a priority for everyone. I love the temperature control and that my partner and I can set our side to each of our likings. I also love the gentle vibrating alarm each morning. I wake up feeling refreshed after a great night's sleep, allowing me to start the day off right. 8 Sleep's technology is incredible. While temperature is the biggest game changer, the pod cover has other amazing features. For example, thanks to the pod's sleep and health tracking, you can wake up to a personalized sleep report for each morning that offers insights on how certain behaviors, like late night exercise or caffeine, impact your sleep and overall health. The pod cover by 8 Sleep truly provides the ultimate sleep experience. I've never experienced sleep like this. And the pod's cooling technology has been a lifesaver this summer. Invest in the rest you deserve with the 8 Sleep pod. Go to 8sleep.com/legalaf and save $150 on the pod cover. That's the best offer you'll find, but you must visit 8sleep.com/legalaf for $150 off. Stay cool this summer with 8 Sleep. Now shipping within the US, Canada, the UK, select countries in the EU, and Australia.
Jewelry is having a big moment right now, and with hundreds of products popping up in your feed every day, it can be hard to find a brand you trust. Alex and Ani has been creating meaningful jewelry for over 20 years, designing pieces that connect you with all of life's important moments. With an emphasis on value, there's truly something for everyone. You might be most familiar with their signature charm bangle. This bracelet literally created the category of meaningful jewelry and had you stacking charms from your wrist to your elbow. This piece is an icon for a reason. Completely size inclusive, each bracelet is adorned with a symbol designed to tell your story and express your unique style. Beyond the bangle, you'll find stylish, affordable jewelry for every occasion, from classic pieces to bold statement looks. Don't know where to start? Alex and Ani makes it easy to unpack the trends you're after and sprinkle in your personality too. Each piece comes with a personalized message and meaning, truly making it the perfect gift. You can take comfort in knowing that you're shopping with a socially conscious brand as well. To date, Alex and Ani has donated over $60 million to nonprofits worldwide, connecting fashion and philanthropy in an easy, fun, affordable way. Visit alexandani.com right now to discover the confidence that comes with a perfectly accessorized piece of jewelry. Right now, Alex and Ani is offering our audience 20% off with code Midas at checkout. Again, head to alexandani.com, that's ALEXANDANI.com, and use code Midas at checkout for 20% off your order.
Welcome back to Legal AF. We are live. Let's talk about what's going on in Fulton County. Word breaking earlier in the day that former Georgia Republican Lieutenant Governor Jeff Duncan has been told to appear Tuesday before a Fulton County grand jury to testify about efforts by Trump and his allies to overturn the 2020 presidential election in Georgia. He said earlier on Saturday, you have Donald Trump spreading heinous defamatory statements about Fulton County District Attorney Fani Willis, lying and saying that she engaged in sexual relations with a gangster that she previously prosecuted, which is just completely and totally false. She mentored a gang member while she was a public defender who said that she was like an aunt to him. And based on that, Donald Trump and MAGA just spreading these vicious lies, misogynistic, racist lies, reminded me a lot of what Donald Trump and Giuliani did to Ruby Freeman and Shane Moss when they said they were trafficking votes and ballots the same way they would traffic heroin and drugs. I mean, real despicable, racist, misogynistic stuff that they are doing. And of course, Fani Willis told her staff, though, just rise above it. Let's be professional. I only show you 1/1000th of the threats that I get every single day, and be professional. Do not speak out about this publicly. We will handle our office in a professional manner. But Popok, tell us what else is going on in Fulton County. We expect an indictment next week or in the next 2 weeks at least. Huh?
Oh, yeah, absolutely. No, I think it's next week. I mean, I was down in Fulton County trying to get whatever I could from the water and the air and talking to people. There's some footage I shot while I was there last week. Let's start. I'll leave the letter to you, which is the response showing the professionalism of Fani Willis, or as I like to call her, full steam ahead, Fani. The three remaining witnesses that look like they're going to be called, and one is already reported publicly because this is all grand jury work, meaning it's secret unless somebody like a witness reveals that they've been subpoenaed. It's not coming out of Fani Willis's office. There's her office actually in the video. It's coming out of the witnesses. So you have former GOP, former Republican Lieutenant Governor Jeff Duncan that we've talked about. You've got former Democratic State Senator Jen Jordan. And the one that I find the most interest in is a journalist who used to be with the Atlanta Journal-Constitution, George, I don't know if it's Chidi or Chidi, it's Chidi. And I've looked at an announcement that he just made about being subpoenaed, and where he comes in as the cast of characters is he accidentally walked into the fake electors as they were meeting and they threw him out of the room. He says in his posting on The Intercept that he said, I went to Georgia's state capitol on December 14th, 2020 to watch the solemn and usually forgettable ritual of a casting of electoral votes. As Stacey Abrams led the Democratic delegation upstairs, Republicans sat in a reserved room on the Capitol's second floor to prepare a slate of their own. This is his reporting. The Republicans threw me out of the room moments after I entered, camera phone in hand, going live on Facebook. When I asked what kind of gathering they were having, they told me it was an education meeting. As it turns out, Donald Trump's election team had sent an email the previous night instructing the group to maintain complete secrecy. This is the type of witness, just the type of witness that Fani Willis wants to put live in front of a grand jury for our audience. This journalist and the others testified in front of the special purpose grand jury as part of the 75 witnesses who did. She could have elected just to have one of her staff get up on the stand and read the transcript. But she thinks, and you can tell from just the way he's written this, especially as a person whose job is wordsmithing and writing for a living, that he'll be very, very compelling. Perhaps the members of the grand jury will know who he is. He was a relatively well-known journalist, and he might be the most interesting person that she brings in. Everybody will be riveted when he gives that kind of testimony. The two things I think are immutable facts is going to be an indictment next week. Could it slip to the following week administratively? Maybe. But I think it's next week. It could have been the prior week, except we knew there were three witnesses, including the one I just described, that had yet to receive their grand jury subpoenas, and that Fani and her infinite wisdom of how she wants to present her case to get her, she needs 12 out of 23 grand jurors to vote for her indictment. An indictment, as our colleague Karen Friedman-Ignifilo, who sought and obtained many an indictment in her almost 30-year career, said is already prepared. It's already ready. It's not developed. It's not a collaboration. It's not a workshop with the grand jury. The prosecutor, having presented all the evidence, then puts up on a big easel or up on an electronic board her indictment. and says, this is the indictment, and asks the jury and tries to count to 12 to get 12 people of the 23 that are in her grand jury box to indict. Now, the other immutable fact, I think, is that it's going to be much more sweeping of a civil RICO type, racketeering, organized crime type, conspiracy charge, and the reporting on the ground, including in the Atlanta Journal-Constitution that I just mentioned, is that upwards of 12 people, 11 more than just Donald Trump, could be part of the indictment. So whereas Jack Smith, as a federal prosecutor, and the way he's running this 8-level chess game, as you mentioned, or 8 boards speed chess game as a chess master, is doing it, he has the luxury a bit to bring the indictment, then go for superseding or amended indictment on new evidence as it's obtained, and then do individual indictments and sort of bring all of these planes in for landing at the appropriate times given the election season. Fani Willis doesn't have that much of a luxury. I think she's got to come out of the box with her entire indictment and all of her people. If the reporting is right that it's 12 or more, I think I've got a pretty good shot, and I want to see what you think, Ben, at naming at least 11 out of the 12 that could be in that future indictment. And I did it on a Popok Porter board, which Salty because I never get this read right with our graphics. There it is. So 1 is Trump. 2 could be Mark Meadows. 3, definitely Rudy Giuliani. 4, definitely Sidney Powell, the lawyers. 5, the litigation bag holder for Giuliani, another lawyer, Jen Ellis, Michael Flynn, Lynn Wood, another lawyer who held in one of his properties a conspiratorial meeting with Giuliani and Flynn and Powell to talk about how to overthrow the results in Georgia, now a disbarred lawyer in Georgia. David Schaefer, who is the head of the Republican Party at present in Georgia, who is also part of the fake electors. Kathy Latham, who we'll talk about as one of the counts here, she was the head of the GOP, the Republican Party, in small rural Coffee County, Georgia. Population, who knows what, but voted 70% for Donald Trump. And yet she opened the door and allowed into the election facilities Cyber Ninja's head, Doug Logan, who's up there on the board, Paul Maggio. And here's some video of her doing that. She's in that little jacket, and these are the guys that are being let in literally in video. Salty, you're so good at what you do as a producer. And that video is in the hands not only of the Georgia Bureau of Investigation, but also with Jack Smith and Fani Willis. The charge there is that she allowed, Kathy Latham allowed these people, cyber ninjas, an outside company that was also being used, that was hired by Sidney Powell, called Sullivan Strickler, to go in, hack the computers, download confidential private voter information, and then give it to Team Crazy, all the lawyers that were filing these 80 or 90 cases around the country and trying to throw sand in the gears of justice and democracy. Everybody's confidential voter information, Republican, Democrat, and Independent. Okay, so everybody should be up in arms about this. They thought they were doing nothing wrong. Apparently, Doug Logan from Cyber Ninjas, the same guy who did the Arizona fraud, left his business card next to the servers when the Georgia Bureau of Investigation went to go and find out why did they let third parties in to download information. That is going to be likely. And this has been reported since last summer by the New York Times. This cyber breach, this computer breach, as part of Fani Willis's investigation. This is going to be one of her predicate acts. She needs 2 underlying predicate acts to support her conspiracy. One of them is going to be Kathy Latham, Paul Maggio, Doug Logan, and Sidney Powell and others breaking into computers to steal voter data. So I think we're going to see that. And so that's I got 11. I had 12. But if you'll remember, Ben, in our audience, Burt Jones, who was a lieutenant governor, a Republican, she wasn't able, Fani Willis, to prosecute him as part of her special purpose grand jury, at least, because she had done some sort of inadvertent campaigning for an opponent where she did a fundraiser, and Judge McBurney, who's the chief judge of all these things, said, you know what, that doesn't look right. I'm going to turn that over to another prosecutor. So I don't think he would have been my 12th otherwise because of his role. One last reason, I think, one last data point that I picked up for next week being the week is Judge McBurney is responsible for all things grand jury on a rotated wheel next week, and getting the gang back together again and reforming the band of McBurney and Fani Willis just seems too perfect for next week, given the way these grand jury subpoenas are coming out. And then because he knows it's coming, and Donald Trump keeps telling people at rallies and in fundraising efforts that he's about to get indicted again, he can't help himself to not just call her part of the fraud squad, which, by the way, is 3/4 African-American, one being Jack Smith, one being Alvin Bragg in Manhattan, one being Letitia James, the Attorney General of New York, and the other being Fani Willis. So you can get the racial dog whistle that he blows every time he throws those pictures up. But then he went, forget the dog whistle. He said the disgusting, racist, quiet part out loud, which I'm going to let you talk about, Ben, because you also got that letter. And then she had to respond, Fani Willis, to her team about these disgusting habits and by the way, these things that you're about to say, this is what Republicans have done historically to try to drive a wedge between the American voter and who they want to choose, using racial tropes. Welfare queens who have Cadillacs, felons who are black who get out of jail and murder people to try to defeat Democratic candidates has been going on for 100 years. And this is just yet another example.
No, I hit some of it at the top of this segment. I mean, I don't want to even give it all that much time because it's so disgusting, but Donald Trump accusing Fani Willis, Fulton County District Attorney, of having sex with the gangsters that she prosecutes. And when you go through, like, where's that even coming from? I mean, obviously it's so despicable and defamatory and Donald Trump makes things up, but like, where is this heinous lie? Like, is it rooted in something? And what propagandists do historically, dating back thousands of years, is they take a kernel of something and then they manipulate it and lie about it. And Donald Trump's being represented by a lawyer to a lot of the hip hop stars, which is probably how he got some information on Fani Willis. But when Fani Willis was a public defender, she helped rehabilitate one of the clients that she was representing, who said that she was like an aunt to him, and it was like a loving family relationship, and got him on the straight and narrow again, and helped his life. And so based on something like that, Donald Trump basically said, well, she has sex with the people who she prosecutes and the gangsters, and went out there and said it on multiple outlets, said it in a speech in New Hampshire, had Newsmax ask him the question in an interview, taking out ads about that, in addition to saying all the other heinous and horrific things about her. And then Fani Willis sent a letter to her staff at the district attorney's office, just letting them know that I know that you all will be very protective of me, and that and that you're very supportive and would come to my defense, but please don't, she basically says, please don't take the bait here. Do not respond. Nobody's above the law here. And I don't take things personally. I'm going to handle things in a very professional matter. Do not make any public comments about any of the things that you see right now or in the coming weeks. And she signs it. Fulton County District Attorney Fani Willis, please make it an absolutely phenomenal day and stay safe. And it's just one of the things that we talk about here time and time again on Legal AF is an evidence-based legal system, law and order. Look at what Judge Chutkan is doing. Look at what Judge Lewis Kaplan is doing. Look at what judges who just follow the law, no one's above the law, look what they do, and compare that to the Judge Aileen Cannons. compare that to what Republicans are doing each and every day. And it shouldn't just be that, okay, well, there's one political party that follows evidence and the law. Like that shouldn't be what the system is, in which both political parties should follow the law and evidence. It shouldn't be like, okay, that's the Democratic Party right now. But unfortunately, that's what it is. And the gaslighting is so outrageous and through the roof. I don't want to belabor this Hunter Biden story because, frankly, Hunter Biden was not in the government. If Hunter Biden committed a crime, prosecute him. I really don't give a crap, frankly, what one way or another. Okay. Unlike Jared Kushner and Ivanka, who profited, we know this with evidence, not based on saying, oh, I think this happened. We know with evidence they made $640 million when they were given positions in the government where they couldn't even secure security clearances for. We know that Jared Kushner was put in control of Middle East policy of America and couldn't get a security clearance because he was compromised because, and then the Saudi crown prince, MBS, said, I have Kushner in my pocket, and that Kushner may have given the crown prince a kill list, which then the crown prince used to kill his political enemies in Saudi Arabia, and then gave Jared Kushner $2 billion to manage when Kushner was never a fund manager before. And then the Saudi Sovereign Wealth Fund golf tournament, LIV, gets played at all of Donald Trump's golf courses, or that Donald Trump has secret Chinese bank accounts that we know exist because they were discovered. There's actually evidence for that he paid more money in taxes to China. I could go on this and do 10 podcasts on all of the egregious conduct. But the point is, there's actually evidence to support criminal conduct there. With Hunter Biden, if there was evidence to support Hunter Biden criminal conduct, go for it. I don't care. Hunter Biden he's not representing the Biden administration. He's not in a position of power in our government. And there's absolutely zero evidence that President Biden was involved in anything, from fake audio recordings to fake whistleblowers to saying, oh, bombshell testimony from Hunter Biden's business partner. And then you take the testimony and the testimony says, well, in any of the phone calls that I heard, Biden never got involved in any business. President Biden never got involved in any businesses. I've never heard any way that Biden actually influenced anything at all of Hunter's businesses. Have no knowledge of that at all. And then what do the MAGA Republicans go? Oh, well, it was revealed in the deposition testimony that there were 20 phone calls. Yeah, it was the dad calling his son. The issue is, are those 20 phone calls about businesses and influencing business? And the witness said no, that they were not about that, and that he has no knowledge that President Biden did any of the things that he. So it's just lie after lie. And then MAGA Republicans using Chinese spies as witnesses and Russian oligarchs as witnesses who don't even support what they say. But that's how desperate and non-evidence based they are. Then they're asked, well, do you have the evidence to support it? Hannity asked James Comer and Jim Jordan, do you have the evidence? And what do they go? Oh, we hope so. We hope so. There's a lot of smoke here. Yeah, you created the smoke. You created the smoke. You are the arsonist. And then you're smelling your own smoke and saying, well, we hope so. That's exactly what our legal system is against. And their conduct would lead to them being sanctioned and losing their law licenses. Oh, wait a minute. They don't have law licenses in the first place. Jim Jordan never passed the bar exam. James Comer is not a lawyer, and they don't give a crap about law and order and our legal system. They want to abolish the DOJ and the FBI because there are criminal investigations about domestic terrorists who want to destroy our government and our Constitution. That, folks, is the modern day Republican Party. So the modern day Republican Party has been asking, Merrick Garland, can you appoint David Weiss as special counsel? And then the MAGA Republicans created a conspiracy theory that David Weiss requested to be appointed a special counsel to investigate Hunter Biden crimes, and that Garland refused to permit him to do that before. And then David Weiss sent multiple letters to the Republicans saying, that's not true. I have full authority to conduct this investigation how I want to conduct my investigation. And I've never been limited by Merrick Garland. In fact, Garland said I could be appointed a special counsel, whatever I want to make that designation. I have full authority to do that. But the MAGA Republicans said, no, you're lying. And David Weiss is like, I'm not lying. David Weiss was appointed by Donald Trump. David Weiss is a Republican. David Weiss initiated the Hunter Biden investigation while Trump was in office. And President Biden could have fired David Weiss. But because President Biden didn't even want the appearance of impropriety, he kept on the prosecutor appointed by Trump, who was prosecuting his son when Biden would have been well within his rights to easily remove him. You could always remove the prosecutors, the United States attorneys appointed by the prior administration. That's what everyone does. Like the only one, there was one other, but basically the only prosecutor from the Trump administration that Biden kept on is the one prosecuting his son, who Merrick Garland was then asked, will I have full authority? And Garland said, yes, David Weiss, you have full authority. And then Republicans created a conspiracy theory that David Weiss was now a deep state operative working for Biden. So what happened? David Weiss entered into a plea agreement with Hunter Biden, where Hunter Biden was treated far worse than anyone else with the similar type of crimes, paying taxes late. Many people don't get criminally prosecuted for that. Okay. 2 misdemeanors there and a gun charge for purchasing a gun while he was high, which the Fifth Circuit has said is unconstitutional anyway. So those were the only 3 charges that David Weiss investigated that there's actually evidence of, right? Because we've seen in MAGA Republicans' world, when there's no evidence, prosecutors can't rely on Chinese spies, okay? I know MAGA Republicans think that's funny, that they get to rely on spies from frickin' China to attack American democracy, but prosecutors in the court go, oh yeah, my star witness is the Chinese spy, Iranian, Libyan arms dealer who is lying about Hunter Biden because he wants he doesn't want to go to jail. Or I'm going to rely on the Russian oligarch who works with Putin. No, the MAGA Republicans think that's okay. But the prosecutor charged the crimes and entered into a plea agreement with the ones that existed, which no other American would get charged with that. And then a Trump-appointed judge, this doesn't get pointed out a lot, a Trump-appointed judge in Delaware, a la a Judge Cannon style, basically broke up the plea agreement in court and inquired and gave the plea agreement the type of scrutiny that frankly doesn't exist in plea agreement. Normally a district judge would approve something like this, but this district court judge didn't. I'll leave it at that. Imply what you want to imply from it. But the district court judge, after getting all of these letters from MAGA Republicans in Congress, all influenced the district court judge, sent her letters. You want to talk about real weaponization? How about the concerted campaign to try to break up a plea agreement between the Republican United States attorney before a Trump appointed judge? So that took place. So then, now that there is no plea agreement anymore, finally, the prosecutor, because there is no plea agreement, David Weiss, asked for special counsel status. This is what this was a letter sent by Marsha Blackburn, a senator from Tennessee, Republican, MAGA Republican, and like 25 other Republicans, made this request. And there's almost every House Republican made this request, but it says, "Dear Attorney General Garland, we the undersigned write to request that the United States Attorney David Weiss be extended special counsel, prosecution, and authorities to conduct the Hunter Biden investigation. September 19th, 2022, less than a year ago." Okay. So now, finally, this because he hadn't requested it before, David Weiss requested special counsel status because the tax charges are outside the jurisdiction of Delaware. So now he needs to charge in other jurisdictions. That's why he needs special counsel status. He makes the request. Garland grants it right away, like he said he was going to grant it right away. And now what do the Republicans say? I can show you 1,000 tweets and posts or X's or whatever the hell they're called these days, but this is what Senator Marsha Blackburn, this is what they're all saying. Merrick Garland appointed David Weiss as a special counsel because he knows Weiss will protect Hunter. Now, this is the whole talking point, that David Weiss, the Trump appointee, the Republican prosecutor who began the investigation under Trump, is now a secret Biden operative. And as one commentator put it, and I, that the MAGA Republicans would only be happy if you had Rudy Giuliani or Sidney Powell basically appointed as a special counsel at this point. But when we talk about all of these issues on the show, it's really why I wanted to focus on that angle of this. I don't, the Hunter Biden thing and the Hunter Biden story in general, to me, who gives a crap, frankly? Prosecute him if there's a crime. But I wanted to focus on our evidence-based system because it ties in all of the things we talk about here on Legal AF. I'll give you the final word, Popok.
Well, there's a reason you do a special prosecutor, so he has multi-jurisdictional powers. And I think this is just another example of Merrick Garland sort of doing the right thing. We've got 3 special counsels that have been appointed under Merrick Garland. We've got Jack Smith for all things Trump. We've got Weiss now for all things Hunter. And we've got, Rob Hur for the Biden document issue. And if you look at the Department of Justice guidelines and the law related to special counsel appointment, 28 CFR 601, it was at this moment after the Judge Norika, who is Republican, but she's not MAGA, the prosecution and the defense screwed up that plea deal. The one that it was going to be a gun charge, deferred prosecution, and some tax charge. And both sides actually didn't do well in front of Judge Norika, who had problems with the plea deal. And now, post that hearing a month ago, it looks like the deal has fallen apart because they want the ability from the prosecution side to continue to investigate Hunter Biden. And Hunter Biden wanted to put this thing to bed with the plea deal. And therefore, at the moment when it fell apart, David Weiss asked for broader powers because just as a 1-minute primer, U.S. attorneys have jurisdiction over criminal conduct that happens in their jurisdiction. There are things that are alleged to have involved Hunter Biden, but not Joe Biden. That happened in California, that happened in the District of Columbia, that happened in other places other than Delaware. And he would have to get, David Weiss, as a U.S. attorney, he'd have to get cooperation to have those things happen in those other jurisdictions, including developing witness testimony, not as a special counsel. He can kind of cross-border, go into different jurisdictions and pursue this. It won't, as you already noted, this should satisfy anybody's argument that David Weiss, after 5 years, is somehow conflicted and he can't properly prosecute Hunter Biden. He asked for special counsel powers and he got them. You're not going to give it to him before he's asked for it. What the MAGA don't like is they don't like David Weiss, even though he was Trump appointed. They want somebody else, as you said, like a Rudy Giuliani type or Sidney Powell to be the special counsel. At one time, Sidney Powell was considered to be a special counsel. And now they're they're doing all this in the shadow of a judge who expressed sort of skepticism about the original plea deal. Doesn't mean there's not going to be a plea deal in the future, but it is more likely that Hunter Biden is going to be indicted within the next several months based on the special counsel appointment. And again, back to your original point, who cares? I'll make 2 last historical comments. 1, every White House family has had a black sheep in it that has caused the president some sort of embarrassment. Every one of them. Billy Carter urinated on a runway while Jimmy Carter was president coming off of a plane. But I didn't vote for Billy Carter, okay? I didn't vote for anybody else in their family. And every president and his immediate family has made some money off the guy being in the White House. Every one of them, from Eisenhower to Nixon to Ford to Bush, every family has used the fact that somebody close to them was the president of the United States to make more money for them into the future. It is not a crime. It's called capitalism, and it's allowed. That other people that are investors or that are business partners think that there's a halo effect about having Uncle Joe be in the family tree. That's not Uncle Joe's fault. And that's not his problem. And that other people around them made money on boards of directors, serving on boards or in charitable foundations or setting up foundations. I mean, I love Barack Obama. And Barack Obama had no money when he went into the White House. He's one of the poorest presidents ever in terms of his financial condition. And now he and his wife have made tens of millions of dollars based on the fact that he was once president, not a community organizer, president of the United States. And it's okay. What's not okay is what you said, which is you use your official position in the White House while you're in the White House to feather your nest and line your pockets with money, which is what the Trump crime family did and continue to do, including requiring people that came to town to stay at the hotel that they used to own and pump up the revenue for that hotel. And then everything that you just described about Jared Kushner. It's a big who cares. It's the only thing. This is the last thing that the Republicans have to talk about. And they're apparently now they're just going to waste their entire 2 years when they have the House going after Hunter Biden, because they can't go after Joe Biden. They have no grounds to impeach him. And they're trying to make weight. It's trying to be a make weight to distract from the very real, fact-based, evidence-based prosecutions against their fearless leader. And that's all it is. And, we have to give it a little bit of time because we want to arm people with facts so they can debate it in the streets and around their dinner table. But that's the only reason. The fact that we gave it 22 minutes of our podcast doesn't mean it has any type of equal weight. This is like a bowling ball and a feather in terms of a comparison on the scales of justice related to Donald Trump versus not Joe Biden, Joe Biden's wayward son who had a dark problem for 3 years with drugs.
But the weight that we're giving it, I have no care. I don't care about Hunter Biden. So it's not covering it because here's what happened. I want to show the difference between what an evidence-based system is and what MAGA Republicans are trying to do, and the hypocrisy that they that they exhibit each and every day. I'd say this though about the judge, where I have a slight disagreement with you. If the defendant was not Hunter Biden and anybody else, number one, wouldn't be charged with those 3 crimes in the first place, because very rarely are those crimes actually charged, but fine, charge the crimes. But then the plea agreement the judge would not have peppered those types of questions, and the plea agreement would not have been ripped apart that way. The bottom line, I think, is that the judge felt pressure. She no criminal experience before being appointed by Trump in 2017 or 2018, intellectual property lawyer. I think that she felt pressure from a lot of the MAGA Republicans in the Senate and in the House. It was a hotbed. It was a hotbed political issue. And if she ever wanted to get appointed to the Circuit Court of Appeals or have career advancement, if she blessed that plea deal, I think she recognized that she would be exactly what they do to David Weiss and tarnish him. She didn't want that.
So can I tell you why I disagree with that? And I'll just leave it on this. I happen to know her. I knew her when she was in practice at Morris Nichols. And she's being considered, or had been considered, by Joe Biden to be on the DC Federal Circuit, which is the place where she's a patent lawyer. And I don't know if he's currently considering her, but he had been considering her to elevate her to the Federal Circuit Court, Joe Biden, even though she was a Trump appointee. Her reputation was not MAGA. Was she feeling pressure from other people? I don't know, but I can tell you that it was the gang that couldn't shoot straight based on the reporting in terms of the government making sausage in front of her about what were the terms and the dimensions of the plea deal. And the fact she couldn't get straight answers from either David Weiss's team or from the defense team. I'm not sure any other federal judge would have done anything differently. She may be off the list now from Joe Biden, but Joe Biden's the kind of person to be like, I don't care what she's doing about my son. I think she's the right person for the DC Federal Circuit, who's going to deal with patent cases, and I'm going to elevate her. That would be so Joe Biden if he did that. And lastly, just to remind people, Joe Biden has already announced through his press secretary that if whatever happens with an indictment or a conviction of his son, he's not going to pardon or give him clemency. That is so different from what Donald Trump has said, which is basically, not only am I going to pardon everybody, I want a pledge from everybody running for the Republican nomination that they will pardon me and everybody else because of the weaponized Department of Justice. Just shows you the stark contrast between the Democrats and the Republicans when it comes to justice in this country.
Well, it'll sure be interesting to see now if David Weiss calls the Chinese spy, the Russian oligarch, and finds the 17 fake audio recordings, and you'll see what an evidence-based system looks like, and we'll so to be continued there. But folks, such an honor to spend this time with all of you. The beatdown. Mixing my shows, the legal AFers, the beatdown brigaders.
Well, stays in the pod. Stays in the legal AF pod.
The legal AFers, all of you. Yeah, but it's true. Whether you're a beatdown brigader, a legal AFer, a Midas mighty, a luminary from Lights On, across the spectrum of shows that we have, we're honored to have you here sharing this moment with you, and we really greatly appreciate everything you do for this pro-democracy community. Check out MeidasTouch.com for all of the breaking news. Of course, make sure you check back on our YouTube channel. MeidasTouch.com is the complement to our YouTube channel and our podcast, the new destination for all things pro-democracy, constant updates of all the breaking news. And we've got some of the best writers, best editors in the game working for MeidasTouch.com. We've been able to build that thanks to all of the memberships that we have here. And that's how we fund and build this network, through your generosity. You see the memberships below. That's how we grow this thing. So gift people memberships, get yourself a membership if you don't have it. No worries if you can't otherwise, just share and spread these videos. Get the new Legal AF gear. Karen Friedman Agnifilo is rocking it today. I saw her post, store.MeidasTouch.com, store.MeidasTouch.com, 100% made in the USA, 100% union made. Things are just heating up in all of these prosecutions of Trump. And I have to say, Popok, we've been pretty close in all of our predictions on when these cases would be filed, where they would be filed, and what would be going down. I'm proud of the record that we have, but most proud of all of the legal AFers out there. Thank you. See you next time on Legal AF. Always a pleasure to host this with you, Michael Popok, and to spend this time with all of you. See you next time on Legal AF. Shout out to the Midas Mighty.